Everybody rise for the jury, please. All right, we can be seated. Going to let some of the commotion die down, so just a second. When you're ready, Mr. Bogan.
May it please the court.
Go ahead.
My presentation doesn't start in Biofeedo, doesn't start in Colorado Springs, doesn't start in Durango. It starts in Bakersfield, California. There's a crew out there working for United Pipeline. Crew leader, the man charged in this case, Mark Redwine. He's in his truck away from the men that he's supervising, and I think it was evident in the testimony that working in the fields for United Pipe attracts and employs a rough and tumble sort of crowd, and that's okay. The leader of this crew in Bakersfield on a hot summer afternoon, he's not screwing around with his coworkers. He's not getting up in their business. He's not making sure the pipelines are running correctly. He's in his truck, looking at his phone. Pictures of the sun. Who he's estranged from. Who he doesn't have a good relationship with. Who he's losing. He's looking at the pictures of his son. Playing ball. And he's weeping. And he can't help it. He's working in a place where show of emotion, crying over a cell phone is not what you do and is not generally socially accepted. And he's crying when he's looking at these pictures of Dylan Redwine because he loves him and he misses him. And Freddie Crasium, you heard testify yesterday, he sees this man hovering over his phone over the pictures of his son, weeping because he loves him. Many, many months down the road, years, he sheds those same tears, and Tom Cowling tells him they found Dylan's remains. He loves Dylan, misses Dylan. He wants Dylan in his life. And as the prosecution says, use your life experience, use your common sense. If you want one of your children, your son, your youngest son in your life, you don't kill him. You bring him into your life. That's what Mark Redwine wanted. Even using their analysis of Occam's razor, what's the simplest answer to what's going on here? You want your son in your life. If you want a relationship with them, you don't kill them hours after they arrive to come visit you. I'm going to ask you to reflect on the evidence in this case, the lack of evidence in this case. And on behalf of Mr. Redwine, I'm going to ask that you return to not guilty verdicts. Not guilty of murder in the second degree, not guilty of child abuse resulting in death. You've seen a lot of witnesses testify, and there's been a lot of questions about why are you testifying for this side? Why is this side calling you? What are your motivations? What are your biases? I think it's pretty evident. I'm a defense attorney. Moran's a defense attorney. Mr. King's a defense investigator, so is Mr. Lister. Sometimes it gets posited, are you representing this man? You have to. That's even been posited in different ways to different witnesses. We stand shoulder to shoulder, Mr. Mark Redwine, because it's our honor to stand with someone who's wrongly accused. It's our honor to defend someone and fight and object and argue and introduce evidence. It's our honor to do that, especially in a case where someone's been wrongly accused and the evidence is so thin and the emotions are so high. The not guilty verdict from this case flows from the evidence in this case, the lack of evidence in this case, science, the testimony, and the not guilty verdict flows from what you know about this case now. You guys have become experts on what's going on in this case, more so than probably a very small number of other people in the world. And it's what you know about this case, not what the prosecution wants you to think happened in this case, not what the prosecution wants you to speculate about what happened in this case, but what you know from the evidence and lack of evidence. We do these trials in a special building, a courthouse. We got rules. People can talk at certain times, and there's stuff you got to do when you're sitting as a witness, there's stuff you got to do when you're asking questions, and all these rules, this edifice that you sit in now, it exists for victims, for families. It exists for Mr. Mark Redwine. And out of all this process, we lurch slowly towards some definition of justice on a grand scale, and more importantly, on a small scale in this case. And I submit to you, justice does not get achieved by returning a guilty verdict when the wrong person has been charged. Justice is not achieved, closure is not achieved when the wrong person gets convicted. Now, this edifice, this process exists because the Redwine is presumed innocent, and the burden is on the government to prove to your satisfaction unanimously, otherwise beyond a reasonable doubt. But because of those rules, I get to talk once today. Prosecution gets to bat twice. So I'm going to say my bit on behalf of Mr. Redwine. Mr. Doherty's going to listen, he's going to get up, he gets to talk one more time. And as you listen to him talk, think about this edifice, think about why this building is here, and think about what Mr. Redwine would say. Think about what the evidence would say, the lack of evidence would say to you when Mr. Doherty gets back up to talk in a little while. I submit to you, because of the evidence and the lack of evidence in this case, justice is a not guilty verdict. Justice and the verdict in this case should flow from truth and facts and science, It shouldn't flow from hatred, disgust, bias. It shouldn't flow from speculation, innuendo, or unjustified interest. The verdict in this case should not flow from what you think might have happened. You're confined to the evidence and reasonable inferences therefrom. I listened to Mr. Doherty talk. I didn't count them all, but I heard him say these phrases a lot when he was addressing y'all. A lot of the time, he'd say, maybe it was this. Maybe this happened in the living room. Maybe this happened in the living room. You think maybe this happened. You think this happened. I can't tell you what happened in the living room November 18th, 2012. After 9 years, 5 weeks of trial, all this investigation, they can't tell you what happened. He said, can you imagine? Can you imagine if this happened? Can you imagine if that happened? Can you imagine if he said, F you? Can you imagine if he said, hey, shit-eating shit-eater? Can you imagine that? Or what if this happened? What if this happened? Maybe this happened. When someone's on trial for murdering their youngest son, and the prosecution's thesis is what if, or maybe, or can you imagine? That's a window into how weak the evidence is in this case. When the thesis of the government is, can you imagine? What if? Maybe this happened. When they're starting off with maybe, your deliberations end with not guilty. These are the bullet points. This is what I'm going to talk about while I got your attention this afternoon. As I've listened to the testimony and looked at the evidence, I submit to you respectfully. The government's case is based upon the manipulation of science, targeting someone, in this case, Mr. Redwine. It's easy to hate and dehumanize. Their case flows from a biased investigation and an impossible timeline. And I'm going to talk about each one of those in turn. And I'm going to beg your patience while I do all that. But before I get into that, I got to talk about some other stuff first. Your verdict should flow from facts and science. Who you believe, who you don't believe. Maybe you believe part of it, maybe you believe some of it, maybe you don't believe any of it. But justice and verdicts flow from facts and science, not speculation. One of the instructions you got from the court, and we talked about it during jury selection, was beyond a reasonable doubt. And as you can read, and you actually have this instruction in your binders, the doubt based upon reason and common sense. That's why we use the term common sense a lot during closing and opening arguments. It comes from a fair and rational consideration of all the evidence, lack of evidence. Reasonable doubt is not vague, speculative, or imaginary doubt. It's such a doubt as would make reasonable people hesitate to act in a matter of importance to themselves. We talked about how this is lawyer talk, law schools talk, all during jury selection. But it's the lack of evidence, the evidence itself, the uncredible evidence, makes you hesitate during your deliberation, at the conclusion of your deliberation, if you are still hesitating, as you would in a matter of importance to yourself, then the verdict is not guilty. Reasonable doubt resides in that hesitation you feel in your stomach, in your mind, when you think about the gaping holes of evidence in this case, and how the prosecution's theory in this case runs contrary to science. It's that hesitation you feel in your mind, in your heart, in your stomach. beyond a reasonable doubt, and I don't even think they can get this far. I mean, you think, well, I don't know, maybe he did it. If your consensus is maybe he did it, the verdict is not guilty. Well, I don't know, he's the last person to see him according to the prosecution, and, you know, Dylan was walking 2 feet away from him at the airport, so he probably did it. Probably. He was not guilty. Well, you know, they called this one human remains detection dog expert, and they called the other one. I don't know what happened. You don't know what happened? That's not guilty. The thing about reasonable doubt is that don't have to be unanimous. Reasonable doubt can be something different for each and every one of you. Reasonable doubt can be the fact that the most overwhelming evidence of injury to Dylan Redwine is animal scavenging. For another one of you, reasonable doubt may be the absolutely underwhelming, pedestrian, unremarkable DNA evidence in this case. Another one, you might have reasonable doubt because you just don't think that dogs can tell people that though something is not there right now, that thing was probably there about 110 days ago, based upon the way the dog sits and looks at its owner. Reasonable doubt might be that there was DNA from another man found in the vicinity, in the same place as the first set of remains. Dylan Redwine. You guys don't have to be unanimous in reasonable doubt. It can be something different for each and every one of you. Philosophically, reasonable doubt flows from the government being unable to produce to you any sort of weapon. Reasonable doubt flows from the government being unable to articulate to you over 5 weeks what the cause of death is. Reasonable doubt flows from the fact that there's no evidence of a fight, that there is no evidence of cleanup. There is no credible evidence, and we'll get into this. I got the afternoon. There is no credible evidence of motive. Reasonable doubt flows from the fact that nobody, on the day after hunting season was over, when there's a lot of traffic in that part of the world, nobody saw Mark Redwine drive to that little neighborhood up there by the campground, go to the general store in Vallecito, take a left and drive up Middle Mountain Road. And reasonable doubt also flows from the fact that the government, the prosecution, the district attorneys from Boulder and Durango still can't provide you an explanation of what happened. So as you look at the evidence in this case, as you look at the science in this case, as you look at the lack of evidence in this case, as you look at the credibility of certain witnesses, you are obligated, as the court has armed you with this instruction about reasonable doubt, to see it through that filter. This is what the government has provided you with. You've heard testimony there was a bad divorce. We'll get into that. But Dylan did not want to go to Vallecito. The pictures. Walmart. He had plans to see his friends. Still more stuff about the pictures. You heard about the baseball road trip. The front porch light apparently being on at 2 o'clock in the morning. That Dylan was an almost habitual texter. They provided you all this prequel, and they provided you this information. 1.9 nanograms of presumptive blood. That's the one portion of biological material in the living room that's not a mixture. That's the one that was a match to Dylan Redwine's blood. And as we know, 1.9 nanograms is 1.9 billionths not billions, billions, TH, 1.9 billionths of a gram. They presented to you a normal-looking living room. Evidence that the postcranial remains were scavenged. Provided you evidence. Cranial fractures, cranium, skull, bone. Cranial fractures, consistent with taphonomy, which means natural causes. They provided you with two minuscule, thinner than a millimeter, marks on the zygoma. And they've also presented you with testimony of dogs making their owners happy in the form of human remains detection dogs. What they have not provided you with, the zero here, is what they think happened. It's what happened. And as they said, as Mr. Doherty said, he can't tell you. And if the government, if the prosecutors, if the La Plata County Sheriff's Department, Federal Bureau of Investigation, Colorado Bureau of Investigation, National Forest Service cannot tell you after 9 years what happened because they don't know, if they don't know, you don't know. You may not like the pictures of Mr. Redwine, and you may not approve of the way he handled himself during the search for his son. And you may not approve the way he handled himself during the divorce. You may not approve of a lot of things he does. But if they don't know what happened, you don't know what happened. If you don't know what happened, regardless of your opinions of the defendant and how he comported himself while his son was missing and dead, you must return verdicts of not guilty. The verdict form does not say, do you approve unanimously of how this man acted when he found his son was missing? The verdict form does not say, do you approve of the way this man spoke to his other son, Brandon? The verdict form doesn't say, unanimously, would you, as loving parents, children, family members, have done something different? The verdict form is limited to the crimes they charged him with. The verdict form is limited to the story after 5 weeks that they cannot tell you because the evidence does not support a guilty verdict. And they've even told you, we don't even need remains. We'd be here even if there weren't remains. We would go on innuendo and these facts alone. That's good enough for us. We'll get into the bias investigation in a little while, please. Point being, you got to know what happened to convict. If you're going to convict someone of killing their youngest son, you have to know what happened. And if you don't, without hesitation, you must return a not guilty verdict. As I understand the government's case, there's 5 parts. The father, Mark Redwine, the drunk, cross-dressing, feces eater, with homicidal rage about his proclivities. They allege his youngest son, Dylan, confronted him about the cross-dressing, feces eating. So he killed his youngest son, decapitated him, dismembered him, and spread him around the hills with pathological surgical precision. To navigate to a guilty verdict, you've got to buy into all 5 parts of that. You got to buy into all 5 parts of that. You have to buy into that as you look at the elements of all the charges here and buy into that beyond a reasonable doubt without hesitation. If one part of those 5 parts doesn't work for you, that's not guilty. And as I'm going to talk about here in a minute, their theory defies reality, facts, science, and common sense. You don't have to be a scientist to get to not guilty here. You just got to have common sense. The science kind of helps a little bit, though. Common sense begs the question here. Is there more evidence of a young boy leaving his house, an animal predation and scavenging, or is there more evidence of this unsubstantiated, ghoulish fantasy that the prosecution has posited? When you look at the evidence, right, when you look at what was found, what wasn't found in Middle Mountain, what was found, wasn't found in the house, Is there more evidence of animal damage, or is there more evidence of this ghoulish, feces eating pictures, temper tantrum, killing, decapitation, dismemberment, driving into the hills, spreading dead body parts all over Vallecito? I mean, that's not a bad place to start your inquiry. What do we got here? Targeting a defendant is easy to dehumanize. Why is he easy to dehumanize? Government case. Is it easy to dehumanize Mr. Mark Redwine? Yeah, they got the pictures of him eating feces out of a diaper while cross-dressing, posing, taking selfies. That's pretty easy. Is there any credible evidence about him having a homicidal rage about the pictures? I submit to you, I'm going to talk about it in a while. No. Is there any evidence, as you reflect back on what you have seen and heard over the last 5 weeks, is there any evidence Dylan confronted him about the pictures on November 18th? I submit to you, there's no evidence he killed his son, and we'll get into that in a second. Is there any evidence that a man who works as a supervisor in the oil fields for United Pipeline has the know-how and ability to decapitate, dismember his son, clean up the entire place where they think this happened with surgical pathological precision, and then take those body parts, spread them out all over the area outside of Vallecito? Is someone capable of doing that, given their education and experience? And I submit to you, there's no evidence you could have been able to do that. Please. So we have the government's case is based on the pictures. They introduce the pictures as evidence. They want you to believe that these pictures will provide some enlightenment to you about the motive that they ascribed to Mr. Redwine for killing his youngest son, whom he loved. They introduce these pictures, but they don't want you to look at them. I'm going to show them to you. Do not fall for that. The prosecution likes these pictures a lot more than they like the tangible and scientific evidence in this case. They like those pictures more than they like the fact there's uncontested damage by animals to the remains. The marks on the cranium are consistent with animal damage. They like those pictures better than the fact that the DNA evidence is contradictory and underwhelming. They like those pictures better than the dog alerts being unscientific, that the timeline makes no sense, and that there's no facts in hand as you go to the deliberation room to support some sort of picture compensation theory. All right, what can you think? All right, you got these photos. No one wants to look at them, but they're in evidence. Prosecution is saying this is going to possibly provide you with insight into what they say the motive of Mr. Redwine was to supposedly kill his youngest son. We talked about this during jury selection, but your commitment to the rules, the law that the court has provided you, don't stop and end at jury selection. They don't stop and end, really, ever, until you render a verdict. And you may only view the pictures for the sole purpose of seeing if that helps you understand what their thesis is, what their argument is regarding why a man who fought for the custody of his youngest son during divorce proceedings for at least 5 years would kill his son. And if you do not confine your analysis of those photos to the sole purpose of, does this help me understand what they're describing as motive, then you're coloring outside the lines. You got to throw the handbrake. You can't do that. And every one of you has assured us during jury selection that you can do that. And I have faith in the system, has faith that you will. But do not get washed downstream by the photos. Do not get washed downstream. Say, well, The person who engages in this sort of conduct is probably a pretty freaky, bad person. And because they're kind of a freaky, bad person, they probably would be the sort of person to kill their youngest son after they fought for him to get custody of him after a really bad divorce for 5 years. Can't do that. You look at him, you're like, does this motive make sense? Does this help me understand what they're saying motive is? Please. We can skip this slide, I think. Use your common sense. Let's keep going. I did a lot of slides. When you go to the deliberation room and you reflect on what the prosecution has said about motive, if you acknowledge there is no testimony and no evidence that on or about November 18, 2012, that Dylan confronted, questioned, asked, heckled Mark Redwine about the photos, if you acknowledge that that evidence does not exist in the record that's flowed from this witness stand, if you acknowledge that there is no evidence of that, if you acknowledge that that motive, that we think that maybe Dylan, a 13-year-old boy, and we're not going to say it was the only 13-year-old boy who was having a difficult time with his dad. If you think to yourself, well, we think that Dylan was a 13-year-old boy who was having a difficult time with his dad, didn't want part of that relationship, and either told his dad, fuck you, shit-eating shit-eater, I don't like you because of these pictures, you're a bad dad, don't talk about my mom that way. If you think that maybe he did something like that and that triggered his dad to kill him in some way or another that we can't define, if you acknowledge that there's no evidence, that there's no there, not guilty is the verdict, you must return without hesitation. Which comes back to what they would say is the theme of Mr. Bogan's presentation. Are you going to rely on evidence? We'll get into the evidence in a minute. Or are you going to rely on speculation? The speculation being, according to the two women who went to Mr. Redwine's house, on the same day he found out definitively that Dylan was dead, and yelled at him from a car at his house, and drove up right to the property line and started yelling at him. Do you believe them when they say that when you call out Mark Redwine for being a shit-eating shit-eater, he goes in homicidal rage, he kills you? So is that what you want to hitch onto? Or do you want to look at the evidence and science and lack of evidence in this case? And I submit to you, I think it's pretty obvious what I'm asking you to do. I'm asking you to look at the evidence. I'm asking you to think about the testimony. I'm asking you to think about what we are actually dealing with here and not the raw emotions of a community and family getting absorbed by the tragedy of Dylan going missing and Dylan's death. We can skip this slide. I talked about that. Let's talk about the manipulation of science here and what the prosecution has provided you. I want to talk first about forensic anthropology, please. Heard from a couple of forensic anthropologists. The terms got batted around a bunch. And there's terms, I think you guys have taken notes, that you're going to have to grapple with here. Perimortem, what does that mean? Taphonomy, what does that mean? What is forensic anthropology? And forensic anthropology is basically PhDs in anthropology looking at bones and trying to figure out what kind of damage has been done to that bones and in what windows of time that damage is done and what, if anything, they can say about that damage. We don't know. The prosecution would have you believe that a partial cranium on the open range for after 2 years, being subject to livestock, bears, coyotes, mice, birds, mountain lions, bobcats, birds, sun, more sun, rain, erosion, temperature changes, water runoff, and actually 3 years, that's my typo. You have a partial cranium that's been up in Runlet Park for that long, and it is covered in animal damage, but for the opinion of one forensic anthropologist that says 2 minuscule marks on the zygoma are concerning to her or suspicious, the prosecution would have you believe that this cranium that's been in the wilderness for years and years and years and subject to all sorts of natural taponomic abuse, they would argue to you that those 2 tiny marks are emblematic of a father killing his son. And I submit to you that is not supported by the evidence, and that is not supported by science. And you've got an exhibit to look at that on one of these poster boards, where you can see with open range, see there were cattle up there. And even, we'll get into what Dr. France's analysis was of this in a second. But we also know that on top of the cattle up there, we know from Daniel and Leah Foster where the cranium was found. And no, they're not wildlife biologists. They're not forensic anthropologists. But they are people who know how to walk through the woods and are good enough at it. They don't even need a trail. And they like going on adventures. They don't mind going into the wilderness area. They don't mind going into Runlet Park. But they also know how to protect themselves in those areas as well, and to make sure they don't get attacked by animals, that sort of thing as well. So they're vigilant. And they go out hiking in November 2015, and they find the partial cranium. Where do they find it? They find it in an area that they describe looks like a coyote den, something would feed. And there's animal hair stuck on the trees around there, and there's grass pushed down. And as you might remember, they're kind of transplants, or at least they were in 2015, from Louisiana. They're still excited about seeing snow. So they went looking for snow. They go and find some snow not too far away from where they left the cranium, and they see bear tracks. And it's at that point, though they're not wildlife biologists, and though they're not forensic anthropologists, they see the bear tracks within spitting distance of where the cranium was, and they decide that their adventure, their hike is over for the day. They get out of there. We also know from when the Florida County Sheriff's Department went up there that they found more animal remains up there in proximity to where the cranium was found. Yeah. Dr. France. She made some findings regarding the remains, subcranial remains, or some, I guess I call them postcranial remains. That's all the bones she found from beneath the head. She noted the taponomic, aka natural damage to the cranium. She noted the animal damage to the zygomatic arch. On cross-examination, when I asked her, she said the cranium, when she received it in 2015. 3 years after, November of 2012, she said when she received the cranium, it was still in the perimortem phase. Let's review. Perimortem refers to that period in bones when they still retain the elasticity, bending, wetness of live bones. Now, why is that important? We'll get to that in a second. We also know, even from Dr. Kurtzman, the forensic pathologist, that Dr. France changed the cranium forever with her failed molding process, thus changing the evidence in this case forever after she was done with it. What do we remember about Dr. France? Very charismatic woman, very smart. Her mold failed here. She destroyed parts of the zygomatic arch. She denied that she changed those parts. She's not a tool mark expert, but she is a scientist. And she's a scientist who'd have you believe she's so eminently qualified to talk about what a dump site looks like, right? Usually where people deposit a body, based upon my anthropological experience, is that when bad people dispose of a body, they do it downhill, close to their house, by a road or a trail, and these are all theories that Dr. France believes in, she testified to you about. And she's also the architect of the, if you want to find a human head at the bottom of a hill, just throw a bucket off the top of it. We just do the bucket test. You just throw a bucket off the top of a hill, bucket will probably land next to a skull. You can consider these things in determining how much weight to give her opinions and her testimony. There were omissions from her report that she testified about in this courtroom as well. And even she offered no opinion as to cause or manner of death, and even she said that the fractures to the cranium are best, most conservatively explained by animal scavenging. Subcranial remains, a couple of femurs, a tibia, and a clavicle. Overwhelmingly, all the damage to these, and you'll get to see them if you want, done by animals. And what Dr. France told you, and what Dr. Bruce Anderson reiterated, and even what Dr. Kurtzman reiterated, is that the subcranial remains, the long bones in this, offer you no insight into what happened to Dylan, meaning there's no tool marks on there. There's no evidence of dismemberment on there. There's no evidence of decapitation on the clavicle. There's no evidence that there was body processing. All the subcranial remains, all taphonomic, natural damage, no evidence of trauma, no insight into circumstances surrounding death. That's Dr. France's testimony. The partial cranium, even Dr. France had to say and admit and own that there is massive animal damage to the partial cranium. Bite mark on the sphenoid process. We'll get there in a second. Bite mark on the inside of the cranium. On the inside of the cranium, not that far from where this fracture is as well. Scratches, marks, bite marks on the top of the cranium. The overwhelming amount of damage to the cranium comes from animals. One of the things she talks about is how there's a fracture along the coronal suture. You got the frontal. Talks about how there's a fracture, diastatic fracture, that runs along the coronal suture here. And what we know from all the experts who testified about these sorts of fractures is that those fractures in the skull, like all fractures, follow the path of least resistance, which will be the suture. So the fact, and you'll see some pictures of this effect, the fact that the suture split, that just represents not blunt force trauma, but post-mortem animal predation, and that those fractures follow sutures, particularly in adolescents and children's skulls, because those sutures aren't as strong. Well, there was a lot of talk about the fracture, the frontal bone right here above the left orbit. Even Dr. France had to say that that fracture was possibly caused by animal predation, scavenging by either a bear, mountain lion, coyote, or even being stepped on by livestock. Each and every one of those qualify as blunt force, as perimortem blunt force trauma. And let's remember how Dr. France, their expert, defined blunt force trauma. It's either a bone hitting something hard or something hard hitting a bone. That's as good as they get for blunt force trauma. They're not going to provide you with a causation or a weapon or what happened. The best they can tell you, because they are restricted, as we all are, by science. The best they can tell you is something hit something and caused that, and they can't rule out any of those causes. Next, please. There's no impact, no depression fracture, no tool identified. Remember depression fractures? Those got talked about. Depression fractures happen when someone gets hit in the head by something pointy or by like a hammer or something like that, and it's like a little crater, a little depression in the bone. That would be consistent with someone getting hit by a tool or weapon or something like that. That doesn't exist on the cranium. Why is it important that in her expert opinion, after doing thousands of investigations like this and knowing perimortem coming and going, that when she received the cranium, it was still in the perimortem phase. It still had characteristics of live bone. Why is that important? Why is it important that there was still moisture in the bone? Because that means that if she says there was perimortem blunt force trauma inflicted on his cranium, any and all of those injuries could have been inflicted on the cranium up to the day they were found, and really up until the day Dr. France took possession of the partial cranium. That's a 3-year spread. We've talked about this enough, thanks. Oh, but we haven't talked about it quite enough. When you look closely at the fracture on the frontal bone, and this is a blow-up of one of the exhibits, you can see animal scratch marks, animal scavenging marks right where the crack is. So you'll be asked, you'll deliberate this, you'll talk about the issues as jurors. And you got to say, well, is there more evidence that this cranium, the head, Dylan Redwine, was hit by a weapon or a tool or an instrument or a table that no one has identified and can't identify? Or is there more evidence that this fracture comes from a cranium being in the sticks for 3 years, getting abused and fed on by animals? And I submit to you the evidence is clear from Dr. Francis and Dr. Anderson's own testimony what's going on with that fracture. Yeah, we talk about this too. Good pictures of the zygomatic arch. What Dr. France would have you believe, what the prosecution would have you believe, the 2 tiny marks here, right by where the bite mark is, are evidence of quote-unquote sharp force trauma. What we know, and I'll get into this in a moment, about Dr. Anderson's testimony, and I think he made it evident when you're talking about coyotes and bones, he's not to be messed with, that the fractures and the damage we see on the zygomatic arch are consistent with an animal grabbing that part of the skull by the zygomatic, just like that. And Dr. Anderson showed you that. And you can see what the other animal damage is. Now, and you'll be able to have people's 521 with you in the deliberation rooms too. And marks on the zygomatic root from animals does not mean, with any sort of scientific certainty, that there's going to be marks on the underside of the root, especially if the underside of the root ain't there, and especially if the animal that picks it up isn't carrying it around like a change purse, if it's actually carrying it around like a meso carnivore. Like that. Next slide, please. The zygomatic arch was snapped off by animals. Marks on there could have been found up to the day it was found. Dr. France cannot identify what made those marks. A bladed instrument, a knife. What kind of knife? A bladed instrument. What was the width of the knife? What was the length of the knife? Did you look at the width of the marks? Did you measure those? No. Did we look at the width of the marks? No. No. There was a bunch of molding stuff stuck in there. So it's important to recall that, next slide please, the marks on the zygomatic arch are literally millimeters away from where the zygomatic arch was snapped off by some sort of animal. This is where the damage begins, where it was snapped off by some sort of animal. These are millimeters, the blue one. We also know the marks, as they existed when Dr. France got them, are thinner than a millimeter. We're talking about minuscule, it doesn't even come close. Very, very small marks, millimeters away from where some kind of animal crushed that zygoma. Yes. Oh boy. Dr. France gets the the cranium, takes these pictures with her microscope. Then she applies some sort of latex silicone gunk to the cranium to make a mold because she knew it was going to get sent to Texas. And when she does that, she takes the silicone off, and it forever changes these things so that everyone who gets to look at the marks afterwards, they look more like this, then they look like this, forever changing the state of the evidence. Now, she denies that happens. It's really just different angles on the camera and just different lighting. You have the pictures. You can make your own determination. But remember, even Dr. Kurtzman agreed with the fact that the molding process changed what you guys get to look at during this trial. Next. So, cranium examined by Dr. France, goes down to Texas, gets positively identified as Dylan, moves back to La Plata County. La Plata County Sheriff sends the partial cranium, actually hand delivers the cranium, I believe, to the Federal Bureau of Investigation, the FBI, as described by counsel, the best and the brightest. And they just don't take it to any sort of FBI substation. They take it to Quantico in Northern Virginia, where Special Agent Eric Smith works. And Agent Smith has been doing tool mark analysis for the Federal Bureau of Investigation, the best and the brightest in the nation at identifying what tools leave what kind of marks on what kind of materials. And after doing that for 20 years, they send him this zygomatic arch, the whole cranium, and they say, let us know if you think these are tool marks. And he says, it's consistent with a slicing cutting action, but he says, he can't determine if those marks were produced by tools, meaning man-made tools, or by the natural environment, by animals. And therefore, his analysis is, this is inconclusive. The best and the brightest FBI, when they look at the zygomatic arch, they're like, can't touch as animals or a tool. Now, La Plata County Sheriff's Department sent the cranium to the FBI before our team ever saw the cranium. We had to call the FBI witness to come in and testify from Quantico on TV. They didn't call him. We called the FBI because we wanted to arm you with that information. That was done on our watch because we thought that was useful information for you. They didn't call the tool mark expert from the FBI. Dr. Bruce Anderson, he's testified as an expert on forensic anthropology about 12, 15 times and has always done it on behalf of law enforcement. Working for the Pima County Medical Examiner, he's testified across Arizona, now Colorado, and even up in Idaho. And he's done so at the behest of prosecutors, law enforcement. He's even taught law enforcement, homicide investigators, how to process forensically and anthropologically human remains. He's processed more remains, more skeletal remains than probably just about anyone else in the field. And he's been doing so for a very, very, very long time. And he does it in Arizona, and they're going to make a bunch of hay out of that when they get to bat again. So I'm going to get there in a second. But in someone who has processed, examined thousands of human skeletal remains, he's of the opinion that the cranium was heavily scavenged, picked up by an animal, bitten by an animal, carried by an animal, seriously damaged by an animal, and he does not ascribe the fracture in the left part of the frontal bone or the two tiny marks on the root of the zygoma to any sort of perimortem, man-caused injury. Quite the contrary. After looking at the entirety of the skeleton, at the evidence desk here, he determined that, without a question, this cranium was scavenged by animals and not sharp force trauma, not perimortem blunt force trauma. and he's seen animals take apart to see what the result is of animal scavenging craniums, particularly coyotes, more than anyone else. And he knows what those marks look like. And as he emphatically told you, he's very good at knowing what coyote scavenging looks like. And he identified the same animal damage here, and the same animal damage up here. You'll get to look at that in the deliberation room. All the animal scratches coinciding with those diastatic fractures there. All the animal damage along the frontal bone, on the inside of the frontal bone. Next. Can I say you saw him test right? Doctor knows about coyotes. And what the prosecution has posited is, well, those are desert coyotes. There's desert's wide open there, and the coyotes up in Vallecito don't do that, do they? Coyotes are coyotes. Whether they're in Arizona, whether they're in Vallecito, it's the same species. And they're motivated. We'll get into this in a second when we get into vertebrate biology, but they're motivated by the same sort of things, which is energy conservation, nutrients, and their own animal instincts. And what we know, and what Dr. Anderson told the prosecutors on cross-examination, and when they interviewed him, is that he can cite to over 100 times where skeletal remains from the same individual were 5 to 6 miles apart. And that he's been able to do that and has been leading the charge on those sorts of studies for several years. And that all flows from the fact that they can now take one part of a skeleton from mile 1 and one part of a skeleton from mile 7, test them for DNA and say these are the same person. And DNA has changed the analysis on how animals scavenge and disperse remains. And that's in sharp contravention to one of his grad students to whom he advised, who said that 88% of the time, cranium's always found with remains. Dr. Anderson disagrees with someone who we talked about all of this. Another view, same shot, animal damage right on the zygomatic arch. You'll have a chance to look at that. And you'll get a chance to look at all these. And the point I'm trying to make here is that the evidence of any sort of blunt force trauma being inflicted on Dylan, the 13-year-old boy, by Mark, is not even scant. The damage that you've seen and been testified about this is overwhelmingly caused naturally in the environment. Still, next. Dr. Kurtzman, the forensic pathologist, he told you about his definition of homicide, which is a death caused by someone else, not caused by themselves. And what we know about Dr. Kurtzman is that he wasn't officially brought onto the case until 2018. He had heard about the case. He went to go look at some subcranial remains back in the day, but he wasn't brought on to the case until 2018. And he had to rely on a lot of different materials in his determinations about what happened to Dylan Redwine. And those materials included, and were all provided by law enforcement, a map depicting Middle Mountain Road with locations and distances that they think are relevant. The La Plata County Grand Jury indictment, the probable cause affidavit for the extradition, a timeline of electronic devices, some work product drafted by Jim Ezell and Tony Goldbright, the drawings of the Redwine house that showed the supposed dog alerts, photographs of where there were luminol hits in the house, photographs of where the dog supposedly alerted on the truck, a composite skeleton, it's actually one of their exhibits, of what was found up on Middle Mountain. So he's asked to deliver a scientific opinion about cause of death and manner of death. And he doesn't look at the remains officially to do an actual analysis until 2018. And Obviously, there's not a lot of remains here. That's undisputed. So he's got to rely on basically 10 other reports drafted by the prosecution saying, hey, we found luminol here, and hey, there was blood here, and hey, the dog's alerted here, and here's some businesses that we think will help you decide how to write your scientific pathological report. And he relies on Dr. France's report as well, heavily relies on her report. The one thing they don't tell him is every place where they got all these luminol hits is what the DNA results were in the living room. They're informed, he was informed, yeah, we found blood in Mark Redwine's living room. They didn't say it was billionths of grams. So he gets brought into the investigation late. He's got to rely on all these other reports. And he even said he would have handled this investigation differently. The coroner should have been contacted immediately, and he wasn't on the case in 2018. And if this was done by the book, if LaPlata County Sheriff wasn't in such a rush to get Mark Redwine, there would have actually been a lawful process here of actually pulling in the scientists, the forensic pathologist, and the coroner a lot sooner.
Mr. Bogan, you have about an hour and a half left.
Thank you. So, and Dr. Kurtzman is fine with getting a partial cranium after it's been dropped, handled, cut up, cleaned, and altered by numerous other investigators. He's fine, because now he can just rely on Dr. France's photo. And in fact, he wants to take these lemons of, yes, the esteemed Dr. France, who was processing bodies at 9/11 in New York shortly after the towers fell, totally destroyed evidence. He's fine with that, because he says, the cool thing about that is that when she ripped off that part of the zygomatic arch, that showed that the cranium was in a post-mortem phase, that it was all bleached and dried. So this is a good thing for the prosecution, because then we can say it wasn't peri-mortem. Dr. France already said the cranium was peri-mortem, and what we know is that peri-mortem fractures bend before they break. But you got to consider the source here when he says, I'm fine getting damaged goods, and the fact that these goods are damaged don't really affect my analysis as long as I get to say homicide and come in and testify against Mr. Mark Redwine. And the fact that I didn't put in my report that I think this skull was in post-mortem phase and that the bone that Dr. France flaked off the zygomatic arch shows it's in post-mortem, I just didn't put that in my report, so I didn't want to tell anyone that till it was showtime. That's Dr. Kurtzman. But even he acknowledges that, one, he can't come up with cause of death, and he can't identify a tool that made any marks, and he can't identify a weapon, and he can't say how Dylan died or was killed. All he can do is say, I agree with Dr. France. And if Dr. France is wrong, he's wrong. Yeah. Root of biology. Next slide, please. The issues here are, was Dylan attacked by an animal? Did animals disperse the remains? And you heard some people testify about this. Well, first let's talk about it. You know, the issue is, and you got so many maps. I'm just going old school and using a good old-fashioned topographical map, but you have probably 2-3 dozen maps to look at. One of the questions is whether or not an animal could have brought the remains from Middle Mountain Road to Runlet Park. And we'll get into that here in a second. But first I want to talk about Heather Johnson, the esteemed Heather Johnson. It's undisputed it's huge animal damage, but Heather Johnson comes in. She's the bear biologist. And what did we learn from her? She cares a lot about bears. Did a lot of work here for bears. She defined the start. Now, she talked about her specific case. And the bears, the non-lactating, non-pregnant female bears that she tagged and monitored to see when they were hibernating. And even though she was working on that discrete population of bears, in her report regarding this, research. She talks about how hibernation for bears, for black bears in southwestern Colorado, starts between September 1st and December 30th. Now, the prosecution really wants to push that hibernation out, and Dr. Johnson's research for that discrete subsect of bear population plays that out. But it's generally accepted in the field, bearology, that hibernation starts between September 1st and December 30th. We also know that during bad food years, and everyone here agrees, and it's already been testified to, 2012, November 2012 was a bad food year, that bears will seek out anthropomorphic foods. Anthropomorphic foods, people food, not people have food, trash. Foods that people eat. And therefore bears are drawn into more areas where there are people. She also said, and it's undisputed, bear attacks are very, very rare. And they're very, very rare until they're not. Next slide. Jerry After and Bruce Anderson talked about dispersal remains. I want to talk about Jerry After a lot here, and I think I have some bullet points for him on the next slide. He said basically there's typical behaviors for all animals, and there's atypical behaviors. And there's variation for behaviors of animals depending on the individual and what they're going to do. And quite frankly, I asked him and they asked him, is it typical for a coyote to carry its partial cranium 1.5 miles or even 2.5 miles if they got to get around a ridgeline? And he said, no, that is not typical. But the concept that Jerry After, with his 30 years of wildlife biology and game management, brings to you is that there is no black letter rule or law for animals. We are talking about wild animals here. And while there's typical, usual behavior, every wild animal is in and of itself its own individual, driven by its own needs, energy, whatnot. And you therefore cannot foreclose the possibility that an animal could carry remains that far. All the coyotes, bears, and mountain lions don't get a memo the day they come out of the womb saying, never carry a bone further than 500 yards. That you cannot, with any sort of predictability, say all animals of all the same species always do the same thing. So that's our launching point for this dispersal issue. Because their big thing, right, is that, well, we found the subcranial remains by, I'm going to mispronounce this, Berry Park, and then we found the cranium as the crow flies 1.5 miles away. And therefore, that's got to mean, because these remains were so far apart from each other, that Mr. Mark Redwine was able to kill his son, decapitate his son, dismember his son, cut up the body parts, put them in the truck, drive up Middle Mountain, throw some body parts out the truck by Berry Park, then drive all the way up to around the park, hike down to a stand of trees, throw a head in there, drive back, then go to work the next day. That's their thesis here. Like, because these remains are so far apart from one another, the only explanation it could be is that Mark Redwine killed his son because his son called him out for some pictures, and we have no evidence that that exchange ever happened. And that's a far more palatable explanation than animals as wild animals. What we know from Dr. Bruce Anderson, coyotes range 50 miles. They pick up crania, like this. And they'll carry them 5 or 6 miles through the desert, and there's no reason to think they won't do that. And we have growing data and research that shows that skeletal remains get dispersed by 5 and 6 miles sometimes. And we also know from the lay people, and the cool thing about the instructions you get from the judge is you can listen to an expert and believe some, all, or none, or you can listen to an expert and say, I believe Daniel Foster more than I believe that expert. It's up to you who you believe. Just because someone's an expert doesn't mean you are obligated to believe them. I mean, you're obligated, if you want to think about it, deliberate it. But we know from Daniel Foster, from his own lay description, that the cranium was found in what looked like a coyote den. I know you guys want to hear me talk about DNA some more, and you have been amazing in your ability to pay attention to all this stuff and pay attention to me talking about this, but this is important. the DNA case, the DNA evidence in this case is important. And I'm going to ask everyone, it's the afternoon, y'all just had lunch. Let's do some DNA. I want to talk about the DNA that was found and not found in the house, in the truck, necessarily the clothes, and Middle Mountain. We're talking about very small quantities of what was found in the living room here. A nanogram is a billionth of a gram. A picogram is 1,000 billionths. Therefore, a trillionth of a gram. For reference, a paperclip weighs 1 gram. So when we're talking about 0.6 nanograms of something, we're talking about something that is 6 trillionths of a gram. This comes down to the living room, right? Because their thesis, again, is that something happened, we don't know what, but dude snapped, killed his youngest son, decapitated him, bunch of blood all over the place, right? So what kind of forensic evidence is in the living room is of paramount importance. We got 5 samples. 2 of those samples were tested at CBI for presence of blood. CBI at the lab, the best and the brightest of Colorado, determined that 2 of those 5 samples were not, in fact, blood. They might come back when they get to that again and say, yeah, but luminol destroys evidence. What we got is 1 microscopic, undated droplet of Dylan's blood that's not a mixture. You guys got all sorts of pictures of this living room, but this is what it looks like when luminol gets hosed all over someone's living room. And there were DNA mixtures and 1 non-mixture that were found in this living room. I want to drill down on this in a second. Couch east cushion, 0.99 nanograms, not even 1 billionth of a gram. What we know about that, at least from one of the mixes, is that that's a mix that, 1, not blood, according to the best and brightest. 2, that's a mixture of Corey, Mark, and Dylan. And of those 0.99 nanograms, Dylan's a 1% contributor. Under the rug, item number 3. First time they ran it in 2012, they couldn't figure out how much stuff they were working with. That's why they called it an undetermined quantity. When they ran it through StarMix, they came up with 3.84 billionths of a gram. That mixture presumptively has blood in it. That mixture is Corey and Dylan. Dylan is a 46% contributor. Now they're going to come back and say, well, these percentages are estimations. That's a CBI trying to give an estimate about who contributed chocolate milk and who contributed motor oil. These are the best and the brightest. And they knew this was the Dylan Redwine case. And they ran the data. And these are their numbers. And they don't get to come up with numbers they don't like and say, oh, it's just an estimate. The southeast cushion, again, somewhere between an undetermined amount of stuff and less than a billionth of a gram. Not blood, according to CBI lab work. Corey and Dylan not be excluded from that, but neither can Mark. And it gets kind of weird here because CBI says this is either 63% Dylan and 63% Mark and 36% Corey, but all 3 can't be there. So either Dylan there and Corey's there, or Mark's there and Corey's there, or Corey, we don't know. Obviously, you can't have 63%. What we do know is that there's 3 contributors here, and we can't determine what sort of combination they exist in. Next slide. The coffee table. Not even a little bit over 0.5 billionth of a gram positive for blood. 16% of that contribution is Dylan. The love seat, the non-mix, 1.9 nanograms match for Dylan. But there's 0 evidence on how it was deposited, but for some testimony you heard from Karen Alexander. And also you know for a fact that Dylan had been in that house several times since there was new floor, new furniture as part of the remodel subject to the fire. And we're not talking about massive amounts of material here. We're talking about an event that put almost 2/2 of a gram. Next, please. Corey's in 3 of the samples. Mark's in 3 of the samples. People leave DNA in that room. We're all leaving DNA in the courtroom. Next. This is another one. And all of this has been testified to. When we're talking about the couch east cushion, first CBI said, Mark, Dylan, and Corey can't be excluded. Then they found star mix. They said, let's run it again. Then they came back and they said, with a 3-person mix, you can't exclude Corey and Dylan. And then we said, you guys test that again with the idea that Mark Redwine leaves DNA in his own house? And they came back again. They did, with a 4-person mix, Dylan's contributing 1%. Item 6, corner of the coffee table. 84% Mark, 16% Dylan. Barely over 500 million of a gram. Under the rug. DAs like to talk a lot about this one. Somewhere between an undetermined amount and almost 4 billionths of a gram. 46% Dylan. 2.1, 1.95 nanograms per microliter of Dylan. That's all they got. Everything else is a mix. 5.1, this is a really weird one again, where we can't decide who the major contributor is and who isn't. This one tested negative for blood. What you know from all the DNA testimony in this case is DNA cannot tell you who contributed the blood. And you also know from when Ms. Strub testified is that merely leaving a fingerprint on something, that's even more than a fingerprint, merely leaving a fingerprint on something can leave almost a full nanogram of material on something. So when we talk about these quantities, and there was enough to test, and they tested it, and they got their results. But when we're talking about these quantities, we're talking about what's called touch DNA, the ability to leave 881 picograms of material on something. It's minuscule. It's minuscule. It's tiny. It's naked to the eye. And it ain't as minuscule, thanks, as those tiny little cuts on the zygomatic arch. Oh, actually, it's smaller. We're talking about DNA that's consistent with having been in a room. The truck, clothes, Middle Mountain provide you with 0 DNA or blood evidence. Next slide. This is all the stuff they tested, looking for blood or DNA. Some of it is from Mark's wardrobe. Some of it is from stuff they found up on Middle Mountain. Some of it is from items they took out of the house, looking for potential, what they believe would have been weapons. No actionable evidence whatsoever. And it ain't for trying, and it ain't for looking. But everything that they thought they could find blood on, they tested. And everything they thought they could find DNA on, they tested. And the best they can provide to you is 1.9 nanograms of Dylan's blood. Yeah, but the luminol, we got luminol hits all over the place. And Joe Clayton went in and he sprayed everything with luminol. And Joe Clayton's great with the luminol gun. And, you know, he used the ABA card too, and he even wrote in his report, he used the ABA card in various places, but he didn't write down exactly where. But, you know, we got Joe Clayton, who goes to crime scenes, and he gets to go to crime scenes when they're fresh, and he doesn't have to go to crime scenes or years later or look at photos, because he's a CBI. But what we know from Richard Eichenboom is that luminol will show you when there has been blood cleanup. And that's because, 1, luminol reacts with certain cleaners and copper salts and stuff like that. And 2, if you try to clean up blood with with a mop or a sponge or a towel or a t-shirt, you're going to leave wipe marks on the surface. Wipe marks and scrape marks, that sort of thing. And those wipe marks will not be visible to the naked eye. But alas, they will be visible to luminal. And that Richard Eichmann believed testified is that when you look at where there has been cleanup of blood, you will see obvious cleaning white marks. Corner of the coffee table, no white marks, no cleanup. Floor, Mr. Mark Redwine's living room, no cleanup, no white marks. Love seat, no cleanup, no white marks. Sofa, no cleanup, no white marks. Floor, one of these two is the floor under the rug. No cleanup, no white marks. Now they get to that twice. Now you come back and say you can't tell what the heck's going on with this photo. The TV, a lot of photos, a lot of different kinds of printers. You have the photos. The luminol demonstrates that blood was not wiped up. The luminol, their luminol, Joe Clayton's luminol, demonstrates that stuff was not wiped up, that there was no cleanup, and there wasn't any cleanup because Mark Redwine didn't kill his son. Everyone loves their dog. We got to talk about the dog. We got to talk about human remains dogs. We got to talk about residual scent. We got to talk about the scent line. I didn't talk about this during closing, but I'm going to talk about it because I think it goes to the bias investigation. Ray Randolph and her dog, Stila, they conduct a scent lineup at the fairground. And basically, as she describes to you, she gets a bunch of items from search and rescue, her friends in search and rescue, and some of them are an Nalgene bottle, and some of them's a set of car keys. She didn't document what items she got. They're only looking for a missing child, and she doesn't document how many items she got from search and rescue, what kind of items they were, and she also gets a pillowcase that Mr. Vreeland got from Mr. Mark Redwine's house, and that Mr. Vreeland's dog followed for about 50 yards outside the house and stopped on the road somewhere. But the whole idea here, though she's not certified to do this, never been tested to do this, never been accredited to do a scent identification lineup, the idea here is, let's 10 days after Dylan's gone missing, let's find out if Mark Redwine's a liar. He's lying to us about the pillowcase. So we're going to take the pillowcase, we're going to put it in the middle, spaced out about 5 feet, from a bunch of stuff that Search and Rescue gave us, and we're going to get a hat from Dylan Redwine that was collected from his family and kept in a bag with all the other stuff they collected. And let's see if, even though I've never been certified to do this under the scientific working group to do a scent identification lineup, let's see if my dog Selah will smell the ball cap of Dylan's and say that that ball cap has the same smell as a pillowcase from Mark Redwine's house. And lo and behold, it doesn't work. But lo and behold, when you take a ball cap and other items that were kept in the same bag, and even bags within the bag, and you say, dog, does the ball cap smell the same as whatever other item of Dylan I put out there? The dog supposedly alerts like that. But she didn't really document which clothing or which article she used out of the bag besides the hat. And even though she's not certified to do that, they did it 10 days in, based upon what Selah and Ray Randolph, because they're like, Mark Redwine's lying. He lied about the pillowcase. And so began, and really it began before that, the bias. And what we know from Dr. Haw is that whole process at the fairgrounds is not scientific, not supported by empirical evidence, and that it was a team doing something they're not certified to do. This was our result. But we got to talk about human remains detection dogs and what happened with the house and the truck and Mark Redwine's clothes. The house. The people called Miss Corcoran, and she has a new marital name, it's evading me now. And she talked about how her dog is very, very good at finding dead bodies, and how her dog is certified and trained in how to find a dead body. And she's proud of that, and she should be. The dog has done good work finding dead bodies. But this is a whole different concept we're talking about here. Picture, if you will, this was a 5-week-long drug case. And Mr. Redwine stood before you accused of transporting cocaine in his Dodge truck. And they called a dog handler, and the dog handler said, while we were doing community intervention, we pulled over Mr. Redwine's truck, and canine cocaine sniffer alerted on Mr. Redwine's truck, and he agreed to let us search the truck, and the dog went into the cab of the truck, and the dog alerted to behind the seat of the car, and it gave its final trained response that it believed that some cocaine used to be in the truck. And we never found any cocaine in the truck. We never found any cocaine on Mr. Redwine, but we want you to convict Mr. Redwine for possession of cocaine because a dog is saying something that's no longer there and may have never been there. The dog is saying could have been there back in the day. If this is a drug case, you would disperse with this stuff like that. But we got a dead child, and that shifts the goalposts sometimes. And the goalposts may shift in the courtroom. And the goalposts may shift in the testimony. But goalposts don't shift with science. And what we know from Dr. Hall is that dogs can smell decomposing compounds. And those decomposing compounds come from two sources: dead bodies or a live person who left behind dead tissue, fingernails, hair, epithelial cells, blood, mucus, whatever. But the way science exists right now with human detection, human remains detection dogs, is that these compounds are detectable by dogs, but the dog's only going to detect them reliably if there is a dead body there or there is dead tissue there. Now, no one in this trial defined what large source was, and no one in this trial really defined what small source is. But what was discussed is, well, some dogs alert on large sources, whatever that may be, and some dogs alert on small sources. But the dogs can't tell you what they're alerting on. The dog can't say, I'm alerting on this toenail, I'm alerting on this drop of blood, I'm alerting on this grave soil. Talk science. Because those, as Dr. Haas told us, because those compounds degrade over time, the best practice with human remains scent detection dogs is to see if their alerts coincide with any actual tissue. That's the only way you know empirically, scientifically, if that's working. And this is because the idea of residual odor, though it's mentioned in the scientific working group guidelines, that's a new and emerging concept that is not widely accepted. And residual odor is a whole different concept. Of a dog saying, I think something used to be here, but it's not here now, than a dog actually alerting on grave soil or actual remains. Next. Because residual odor is not widely accepted, there is no scientific working group standard for training or certifying or maintaining or documenting or testing dogs to reliably detect residual odor. Those are working group guidelines to human remains detection, but not for residual odor. And you know what? I dig dogs. I think everyone does. All dogs go to heaven. But that ain't the issue here. The issue is whether or not these alerts are based upon solid science. And I submit to you they are not for the following reason. There's only one study addressing residual odor. That's the carpet square study with 3 dogs, all the same breed, and that was not replicated in any other study. We also know from talking to our experts that anecdotal field reports of like, there was a dead person in that car from back in the day and my dog did a final alert on it. That's not science. That's anecdotal. That is not compelling. Don't confuse the Alexander study, which is testified about, with a study that replicated the carpet square study. Because what happened in the Alexander study is that dogs did alert on areas where remains had been up to several days, weeks, months after the remains had been there. But it was undisputed that the remains had been on top of that soil and that the compounds, the organic volatile compounds, had seeped into that soil, thus making it grave soil, thus making those actual compounds, that tissue that dogs detect, is actually there. That's the difference between those two studies. One, not scientific, we're talking about dogs. The other one, there was actual tissue material stuff there. There is no empirical proof that this stuff works. Please. Talk about contamination and how easy it is to contaminate scent articles. And even as Ms. Randolph said, you blow the scent article with contamination by someone else even breathing on it, you've blown the exercise. Cueing, dogs, even trained dogs, love to please their owner. And if you have a dog doing any sort of scent detection work, and there's an expectation from the owner, the trainer, the other member of the team, or other people in the area, like, it'd be really slow, it would really help our thesis. If you found something here, Fido, the dog is going to pick up on that cueing, and the dog is going to give the responses that it thinks will get it the award and love that it really does deserve from the owner. Next. The close at Area 51, dog alerts on a bag, dog alerts on a blue shirt, dog does not alert on the green shirt. Both the blue shirt and the green shirt came from the bag. Green shirt goes away. Dog alerts on the floor where the blue shirt used to be. You got the items together in the bag, separate, taken away, alert, alert, not alert, alert on floor. As Dr. Haas told you, that's just a confused dog. It doesn't, that you cannot rely upon for any sort of compelling evidence. Next. The house. The living room, again. Dog gave a final response right here. That's consistent with where there was actual material. You know that from the DNA. Dog gave a final alert on the walkway into the house. That area is contaminated. You know that from listening to Dr. Haas. Dog gave final alerts upstairs. Those were false positives. All the other places the dog alerted in the living room, there was no other biological material in the house. So when you get that big blue spot back here in people's exhibit whatever, that dog is alerting on small source biological material and DNA mixtures right there. Next. In Dr. Hall's expert opinion, you're going to have biological materials around for 24 to 48 hours. I look forward to his publication about that. But while he could not cite to a publication saying volatile organic materials associated with death will only stay in a certain area for 24 to 48 hours, there is zero empirical evidence of studies saying that volatile organic compounds will stay in an area for 109 days after a body has been there. Dogs go to the truck. There's no better example of cueing than the trainer, the owner of the dog, lifting the dog into the bed of the truck or lifting the dog into the cab of the truck. Here you go and you find something. Put the dog alerts on in the cab of the truck. Tissue, material up. This alerts on the truck, not credible. You got one of the Google Earth exhibits from us that show where different remains were found on Middle Mountain and where different items of Dylan's were found on Middle Mountain and all the places where the dog alerted on Middle Mountain where there was no stuff there. That's 12 false positives on Middle Mountain. This is uncharted waters. This is unscientific. The positives are either false positives or they're consistent with there being dead tissue left behind. You can disperse with this unscientific dog evidence. One moment. We're going to skip a few slides. How much time do I have, Jim?
55 minutes.
Targeting someone who's easy to demonize. The history of the pictures. Dylan and Corey find the picture. Mark and Dylan go on a road trip. Obviously, they get into some sort of argument, fracas. Dylan demands over and over, send me the poo pic, send me the poo pic, send me the poo pic. Corey doesn't send Dylan the pictures. He sends Mark the pictures. And he sends the pictures with a number of choice text messages as well. Hey, beautiful. You are what you eat. Yes, sweetie, this is Corey. Calls him a sperm donor. You are what you eat. Calls him all these things, and he sends him these pictures. Next. And this is important. You made it through DNA. I'm asking you to listen to this. Mark and Dylan are in another time zone on a road trip, unchaperoned, far, far away from everyone. Obviously, Mark and Dylan are not getting alone, at least during this window of time on the road trip, to the point where Dylan is asking his older brother to send him the photos so he can get his dad with the photos. And Corey, though he originally denied sending the photos, when he was first asked about it on cross-examination, did actually, in fact, send Mark the photos with that litany of insults. But Corey also testified about what Mark's response was to getting these photos and to getting those insults. And if you think about what Mark's response was when he was getting confronted by these photos by Corey, when he was alone with Dylan, who he was already arguing with, and you look at his response, the prosecution's motive for this case arose. As Corey testified, Mark's response to the photos was, don't hurt Dylan. Dylan does not deserve to be hurt anymore. If you care about Dylan, why do you want to see him hurt? But when Mark gets confronted with the photograph, he doesn't turn violent, and he certainly doesn't turn violent towards Dylan. He actually knows and is cognizant the damage these photos can do to his son, psychically, emotionally, psychologically. And the one thing he does is he wants to try and protect Dylan from the photos, not hurt Dylan because of the photos. And that's what Corey testified to as to what Mark's response was when he was confronted with these photos a long ways away, when he was alone with them. Next. Now, prosecution, when they bat again, might say, well, why do you want to do this? They might say this is some sort of weird
spooky. Use your common sense. That's not a threat. That's Mr. Mark Redwine wanting to protect his son from these embarrassing photos and not hurt him because of the photos. To me, the government's theory on North defies the reality of really, however estranged and strained their relationship was, how much Mark truly did care about Dylan, caring for him so much it was not capable of for him to kill his youngest son. Next. People's theories of sort of instantaneous homicidal rage. It didn't come out the Dr. Phil show. It didn't come out on the day Dylan's remains were found, despite the claims of Ms. Berry and Ms. Heck. And you gotta look at their actions and their statements, using your own common sense, and the fact that Ms. Heck, Ms. Berry, very close to Elaine, very taken up in this tragedy. She's very much willing to blame Mr. Mark Redwine for this. I have one moment, please.
Something else I want to talk about is the bias investigation in this case. Obviously, they were trying to catch Mark Redwine early on in the investigation of this case, before a lot of this evidence had ever come back or been discovered or been analyzed. And you can consider about the evidence that Dr. France destroyed, how many times Mr. Mark Redwine's house was searched. They set up game cameras to see when he was driving or if he was driving up there. They put GPS on his truck. They interviewed him repeatedly. They gave scientists police reports. You know from one of the scientists who testified that you like to do, if you're a scientist, your evaluation, your investigation, your scientific work without being influenced by outside sources. They didn't charge the women who were harassing Mr. Redwine on the day he found out his son was dead. They didn't contact Corey and Elaine for protesting outside his house. They took little to no interest in the beer can by the remains. And then there's Angela Lee. And you can look at her testimony and the following testimony thereafter. Does she provide credible testimony that Dylan Redwine was walking down the street through Vallecito? Pardon me. Or does she provide a better window into how law enforcement was treating witnesses who did not suit their narrative? And she went forward to law enforcement and said, I have some information that I think would be useful. Here's what I think I saw. And according to investigator Cowing, she says that she's certain that she saw Dylan Redwine that day on the 19th at about 2 o'clock in the afternoon. She has been interviewed over and over and over again and is told that that's not who you saw. And she said, I saw two boys. And she goes from certain to 60 to 70%. So by the time trial comes here, she's at 40 to 50%. But that lets you understand how much law enforcement wanted to get Mark Redwine. Because as Ms. Lee told you, at a certain point, she was just over it. And she's like, fine, okay, it was two boys. I want to be done with this. I don't want to be contacted by you anymore. Please, just leave me alone. They got a biased perception of evidence here. And what the prosecution, what law enforcement would have you believe is that when they're conducting the search for Dylan Redwine in June of 2013, and they're out there and they're doing that grid and that line, and they're walking up the hill and all that stuff, and they know what they're looking for. They know they are looking for either the possessions or remains of a 13-year-old boy. And as came out in cross-examination, apparently law enforcement and the prosecution would rather have you think that people are up there looking for remains and items and everything, and they throw a banana into a bag of evidence with Dylan's shirt and shoe and remains and whatever else they got up there, and they all just got this in some sort of bag, and that's just, that's just what it is, because banana's superfood, and you need your energy when you're on a search. They'd rather live with that and say that's so. People throw bananas and those wind up in bags with evidence. That's no big deal. They would also have you believe that having no evidence, no log, no entry on the evidence log of where the cranium was from November 3rd to November 9th, that's not a big deal. That the single most important sacrosanct piece of evidence in the case, they don't have documentation of where that was from 11/3 to 11/9, that's no big deal. We had this thing, and Dr. Mulhorn looked at it, and we took it over here, but we don't really have chain of custody on that. That's not a big deal, because, Tanya Goldbright wrote that in her report, kind of. That's no big deal. The fact that we're throwing trash into evidence bags and the fact that we're not keeping a super tight evidence log on the cranium, that's nothing you need to be concerned about. What you need to be concerned about is that Dylan went to the bathroom at Walmart. You need to be concerned that Dylan went to the electronics department at Walmart. And you need to be concerned about the ATM card that was mailed to Mark Redwine's house and then given to Dylan and then deactivated. As you heard Brandy Flan from the bank say, the card had been deactivated. So Mark could not have used that card to get access to funds from the account he shared with Dylan. And Mark Redwine staying home and trying to process his missing son from the front porch, that's a big deal. But these other things ain't such a big deal. Next. Look at this. We got the sticker on Dylan's shirt. We got the receipt. You actually have the real receipt in evidence. There's a reason I introduced a lot of pictures of the kitchen. Nothing associated with that sticker is on the receipt or in the house. So you either have a very, 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 very sloppy investigation going on, or someone put that sticker on Dylan. And that someone ain't Mark Redwine. You also have the evidence log regarding the partial cranium, and you can look at that and the gaps in it and who had it when. And you also have the documentation of who opened that package and who closed it, and where there's very, very important periods of time with very, very important investigators missing. No big deal, they say, that they don't have GPS location for the shoe of Dylan. And sometimes they got GPS results for where stuff was found, and sometimes they have stuff written on a piece of paper. That's no big deal. The fact that we're on this huge, very important search, and we're not keeping track of how we found stuff or where we found it, you can just look right past that. But what you really got to drill down on, the prosecution would have you believe, is Dylan walking with his dad at the airport, the fishing pole. Defense exhibit number 1, picture of the garage, where the fishing pole, kind of up in the rafters, hanging down. FBI missed it, CBI missed it, the Plata County Sheriff's Office missed it.
I'm sorry. Objection, that's mischaracterizing the evidence, fishing pole.
The jury will have the evidence. They can look at it and make their own determination.
First one in our book. They want to make a big new, like there were new floors in there, so Dylan only could have left DNA there like just a few times. You don't have to be in a room a bunch of times to leave that little DNA. They want you to make a big deal of Mark after the FBI evidence response team shows up and the truck's basically across the street from his house, and FBI, CBI, La Plata County sheriffs are all descending on his house, and they want to make a big production of that. And Agent Grusing even said as much and said, you know, we want to, you know, when we do this, I want to let them know we mean business. So they use all that as an interrogation tool, this show of force, right? And when Mr. Mark Redwine says, I have to think of myself, when Mr. Mark Redwine, after he's told by Agent Grusing, we have special lighting and special tools, and if there's any blood in that room, we're going to find it. It's not until after that show of force and after that statement of, if there's anything in that living room, we're going to find it, that Mr. Redwine says, cold sore, Nerf football, and basically responds that, because at that point, he knows he is becoming the primary target of this investigation, and he's scared, and he says that. The prosecution would have you place a lot of emphasis on what Ms. Betsy Hovarth said, an ex-wife of Mark Redwine, reflecting back on a camping trip 15, 20, 10 years ago, I don't know, I think it was like 20 years ago. And apparently you can make that determination over whether or not what someone said to someone 20, 25 years ago is hyperbole, or if they're really saying, hey, actually, if I'm ever going to do this, this is how I'm going to do it. You can use your common sense and life experience to filter out whether or not that comment that Betsy Hovarth attributes to our client is hyperbole or not. But while we're talking about it, by all means. So this is the field log that they started on June 24th that lists where all sorts of items of import were located, and you can look at the global positioning calculations when you get back to the deliberation room. And one thing they say is that the Miller Lite beer can was 50 yards north of the shoe. Cool. So if we have the GPS for the shoe, then we can figure out, by and large, where the beer can was. Next, please. Or do we have it? According to this scientific, forensic, archaeological search of this area, according to Dan Patterson, where's the shoe? Oh, okay. We don't have GPS for that. It's the shoe, by the sock, by the rock, by the squiggles, uphill from the amphibians, and the body dump site. The prosecution's not big fans of the Miller Lite beer can. So they want to create as much distance as they can between the beer can and all the stuff that was found at the first remains site, including where Patterson said the fibula and the tibia were, and the dump site and the shoe and the sock and all that. But we don't know what the GPS is for any of these because they weren't recorded. But we do know that beer can was found in that area, and we do know that on multiple documents it was given the exact same coordinates as where Dylan's remains were found. The Miller Lite beer can with another man's DNA on it. The same GPS location as Dylan's remains. The beer can and the fact that they're expert failed mold forever changed evidence, that's no big deal. What's a huge deal is 1.9 billionths of a gram. Dylan's a 1% contributor. The sofa and the headphones, which Richard Eikelenboom said could have been cut or could have been caused by an animal. He said sheep, and a pillowcase, which Mr. Vreeland took out of the house at his behest after Mr. Mark Redwine said that was in fact the pillow that Dylan had been on the sofa. So there's what law enforcement's choosing to emphasize and say is a big deal and what they're choosing to not say is a big deal shows a lot about how biased and how geared this investigation has been from the start. Even at CBI, we know that you can run the DNA, the partial profile from the beer can on a state database to see if this matches anyone else's profile, because you only need information at 5 of the locations on the molecule to enter it into CODIS. And they got information at 6 of the loci, and they didn't enter it. Now, if this amount of DNA, these 4 cells, is not enough to put into CODIS, when you enter that data into the computer, the CODIS computer say, I'm not doing this, right? So you can try and either see if there's someone else out there, and if there's not enough DNA material on that can, then CODIS is not going to try and match it with anyone else. But you got to try. You can't just say, I don't think there's enough, even though we have information at 6 loci. Next. The motive comes from Ms. Hess and Ms. Berry. I think we've talked about that enough. You got to determine who you're going to believe, how much of what they said you're going to believe, and whether or not it's credible. It's part of the credibility thing. This is what I'm saying. These are things people like to say when they want to convict Mark Redwine. Ms. Burton from Walmart, from my view of all this videotape, he just looked like he didn't want to be there. Have you ever seen any other kids who looked like they didn't want to be at Walmart with their dad, who were 13? Other things people say, it wasn't a protest, it was a gathering. It wasn't a protest, it was an assembly. I did not send my dad those pictures. There were no signs of animals or game trails on that part of Middle Mountain. There were no animal remains by the cranium. Scent lineups and trailing tracking are the same thing. I could see the whites of his eyes. I applied luminol on the ABA card in various places. I don't remember collecting the Miller Lite beer can, but I remember collecting an animal bone. Looking at the photo of the beer can will not help me remember the beer can I collected, and looking at my entry on the evidence log will not help me remember the beer can I collected. If you need insight into what lengths people were willing to go to. The fact that Dr. France broke off part of the skull doesn't affect my opinion. The fact that it flaked off, that I didn't put it in my report, that's no big deal. As Dr. France said, I can tell that's an old fracture, but I can't tell you how old it is. And that certainly didn't make it into my caption of the front. The search party threw bananas in the bag. That one's on. I can't wait to see the look on his face. I hugged him goodbye. These are all statements that people made in this court that don't stand up to the actual evidence. People said there was blood spread out all over the living room. We're talking about billions of grams. The local coroner said she was informed about the remains within 2 to 3 hours. And I said, well, when you interviewed with us, you said it was 2 to 3 days. She says, I looked at the cranium. When you interviewed with us, you said you didn't even know what the cranium was, that you had not looked at it. When I asked her to look at the first death certificate and read it and what it said, she said homicide without even looking down at it to read it. She's like, homicide. Oh, I need glasses. Oh, it doesn't say that. And then the coroner says she relied on Dr. Kurtzman's 28 opinion in her 2013 death certificate. These are the lengths people are willing to go to. And you've got to view all those statements and whether or not they're credible based on your life experience, your common sense, and the evidence in this case. How am I doing on time, Jim?
32 minutes.
You want to do forgive me. last thing I want to talk about is the timeline that the people have provided you really. And what I submit to you is that Mark Redwine, incapable of killing his son, decapitating him, dismembering him, cleaning up all the blood and body parts from that, and dispersing those body parts in the hills above Vallecito. He's incapable of doing that for so many reasons, and I talked about that first and foremost because he loved his son dearly, but also within the time window that the prosecution is submitting, it does not make sense. And the timeline that they've submitted so far, and we can go through this kind of quickly, is Dylan gets in on November 18th, 2012. Mom asks him if he's landed. We know Mark arrives at the airport, 5:48. Dylan arrives at the airport. He even texts his dad, "Are you at the airport?" Next. Mark confirms that he's incoming. Actually, Dylan says that he's at the airport, he's incoming. And, you know, this is another one of those things that the prosecution says, this is evidence that this man killed and cut up his son, is the way they walk into, let's go back to that because I wanted to play it, the way they walk into the airport. Father and a son walking through the airport. Next, they go to Walmart. We know that from the time signatures. This is another thing where we'll just let them play. First place Dylan goes in Walmart is to the bathroom. Been on an airplane, been traveling all day. Roughly while that's happening, Dad's in the produce section. Dylan, after the bathroom, goes to the electronics section of Walmart, consistent with what's been testified to as his enthusiasm over electronics devices, texting and all that stuff. He remains in the electronics section while his dad's picking up groceries. This is not out of the ordinary behavior for a 13-year-old boy to rather be in the electronics section of the store instead of the vegetable section of the store. They find each other in the electronics section, choose some movies. Again, this is not homicidal. I'm angry at my ex-wife. I'm angry at one of my sons. Rage. They're seen walking together through the store. Got to get some stuff here. I want to be balanced. The prosecution would have you believe that this is evidence of some sort of very angry dad at the grocery store with his son, and they walk out together. And you can watch those videos. They've been admitted as evidence. You can make a determination if, as the prosecution argues, this is evidence of a very angry man who was this close to snapping and killing his most beloved son. For some reason that we don't know, couldn't tell you what had happened. They go to McDonald's afterwards. And then, as you know from the reports from the FBI, they arrive in Vallecito, and he's actually been admitted as evidence. They're in the north quadrant of Tower 78. That's consistent with Mr. Mark Redwine's house. Dylan's texting with his friends throughout the day, telling his friends he's on his way, trying to make plans with Ryan Nava, texting with Amanda Saxton as well, who also said that usually it's not uncommon when she's talking to Dylan. If a conversation ends, it's because they've fallen asleep or lost their charge on one of their devices or whatever. And what we do know is that Dylan had spent the night before at a friend's house, was probably up late, and we also know that Amanda had a long day that day as well, and it's more than entirely possible that either one or both of them fell asleep right about at that time when the end of this text message string happens. November 19th, as corroborated by Investor Goldbright, Mark drives from Vallecito to Durango to go to United Pipe to deal with some payroll issues. That's all confirmed by the cell tower information, and we know that he's in Durango from 8:42 to 10:42. Go on. We know that he's at work, as Richard Swayze told us. He talked to him for a long time, never seen that before. But he also said, and you guys got to decide how to decipher this, the most sober and the happiest he'd ever seen him, because he was talking about his son. And Sean Boris confirmed that he was there. Now, the prosecution can't have it both ways. They can't say, well, he was super talkative to Swayze and sober, which means he was trying to create an alibi, and the reason he was all sober and happy was because he's trying to create this fictitious alibi. But then they can't argue through Sean Boris. He looked haggard and hungover and jacked up, consistent with having cut up his son the night before. Mark texts Dylan, you have all of these in evidence. Hey, Boudreaux, you up? Headed your way in a bit. Call me. Calls his attorney. Cell phone information gets him back to Vallecito at about 11:23. Finds out Dylan isn't there. Goes looking for Dylan at 2:24. Drives into the South Quadrant. Then he's back at home at 2:24. He's at home from 2:24 roughly to 3:31. We got that one twice. That's fine. Next. He drives into the south part of the tower, goes looking for Dylan at Tristan Reeves' house, Wesley Rayburn's house, and Fernando Stubbs' house. He eventually makes his way to Bayfield, makes several calls on Bayfield, goes to Corporal Abdella's Bayfield Marshal Station. So, and you got pens and paper and notebooks, you can do the math yourself. There's a lot of information here with the cell towers, texts, call logs, all that stuff. But, you know, however you want to do the calculations, if you want to start your calculations at 9:37, like the prosecution is urging you to, and assume that Mark Redwine went to work 7:30, you want to rely on the forensic phone information that he gets back to Vallecito and he's there from about 11:30 to 3:47. You know, you get a little over 13, 14 hours for all of this to happen. 13 hours for someone who is not medically trained to partake in their ghoulish story. And you have to ask yourselves, knowing what you know about the drive time from his house to the first remain site, his drive time from the house to the second remain site and back, and the amount of medical pathological knowledge it would take to commit this crime and clean it up, that's just simply not enough time. It just simply doesn't work. The notion that the guy working in the oil fields, again, could kill, decapitate, dismember, disperse, and clean up in that amount of time and be able to present at work the next morning like he's the happiest guy in the world defies the reality of the magnitude of the crime that they have tried to describe to you. The magnitude of the violence they are talking about and the magnitude of the cleanup they're alleging could not be conducted by a forensic pathologist, much less someone with no medical training. And they're going to come back and say, well, bodies don't bleed a lot after they're dead because the hearts stop beating. Use your common sense. They're basically alleging that Dylan was cut into pieces in that living room or somewhere else. And that when we boil it down to what they have in this case, to loop back to whether or not your deliberations, your opinions, your verdicts flow from evidence and science, you have 1.9 nanograms of Dylan's blood in the living room, 2 tiny marks on a zygoma that are better explained by animal scavenging. You got a dad who may have not acted the way you would have acted when his son went missing, but they are creating this narrative about rage and anger and photos and deteriorating relationship, and they want you to latch on to this story because the actual physical evidence in the case does not support that Mark Redwine killed his son. And it's, you can, I ask you to focus in on what you know, what you've heard, science and facts, and to not get washed downstream by bias and emotion and everything else. Take a hard look at what you've heard in this case, what you have and what you don't have. And if your deliberations are colored with uncertainty and hesitation, you're not detectives, you are jurors. If your deliberations are colored by hesitation and uncertainty, the verdict should be clear here. And that verdict flows from evidence, not from everything that's around it. That verdict should flow from what you've actually experienced in this courtroom, not statements like, could have, do you think, maybe, we can't tell you, could have. You breathe life into the instructions the judge has given you and what you've heard in this case. I believe the verdict will be apparent to you. And there's a reason you wound up in this room on the state. Find him not guilty.
All right, ladies and gentlemen, we'll take a recess until 3 o'clock. Remember, my admonition not to talk to each other about the case. Don't start deliberating on this case until you've been told to do so. So, everybody rise to agree. We'll be in recess.